Hello everyone. The organizer Femme Forte Foundation has shared a few questions on the topic of the webinar, that is the Consumer Protection Act 2019 read with E-Commerce Rules 2020. I'll take all questions one by one. The first question is, I have instituted a complaint before the consumer against a medical practitioner. My complaint has been challenged on the ground that a medical practitioner cannot be sued under the Consumer Act. What does law provide? My dear friend, I must say, you can sue a medical practitioner. You being the patient will be treated as a consumer. The consumer case is maintainable before the concerned commission, and you are entitled to compensation in case you are able to prove that a medical negligence has been caused in your treatment. Next question. What will happen to already running matters? Will they be transferred to the new forum based on jurisdiction, or will they remain where they are? My dear friend, as per the current direction, the matters will not be transferred from the commission. The pending matters will continue before the commission itself. It is only the new matters which will be filed as per the new act as of now. Next question. Between RERA and Consumer, which will be the best remedy for homeowners? I must say, both the forums are good and provide for almost similar reliefs. However, RERA, being the specialized forum, should be preferred for dispute between home buyers and the developer. A complaint can also be filed before the Consumer Commission. Next question. Suppose minor has purchased a product from the e-commerce website without the knowledge of his parents or guardian and has failed to make the payment for the same in the following situation. A. Can the member of e-commerce have the power to recover the amount of the product from the minor or his parent guardian? B. Can parent guardian claim for the replacement of the product in such case? C. Is minor protected under Consumer Protection Act? To the above questions, will the contract between minor and e-commerce entity be considered valid? That's a very creative question, I must say. First of all, no e-commerce entity will deliver a product without receiving the money. To analyze the situation of minor, that is the contract of the company with the minor, we have to look into the provisions of Indian Contract Act. Indian Contract Act provides that the parties who are executing a contract must be major. It means that minors are not allowed to execute contract under this act. Any contract with a minor, therefore, will be void ab initio, which means will be non-existing from the beginning, non-enforceable. The minor cannot be compelled for specific performance of a contract. Even in a case where the minor has misinterpreted his age and represent himself as a major and the guardians are not aware of. This doesn't mean that there is no remedy available to the person who has, by default, executed a contract with a minor. The courts are empowered to restore the product which is sold to the minor under any misrepresentation. However, it can only be implemented in a case where the product is still traceable or has not been converted in any manner. Therefore, the question posed to us will also be dealt in accordance with the Indian Contract Act, depending upon the facts and circumstances of each case in the given scenario. Next, nowadays, offer and acceptance on online platforms are routinely done in comparison to traditional contracts, which majorly focused on consensus ad idem aspect of both parties. Can these agreements be really called as proper contract, as they are more or less in favor of the seller/originator? I agree with it to an extent that these agreements cannot be called proper contracts. There must be a free consent while executing such contracts. Under the new legislation, the provision for express contract has been incorporated, wherein now it has been made mandatory even for e-commerce platform to seek express consent of the person who is making the purchase. Further, now unilateral and unfair contracts can also be challenged under the new legislation. A complaint can be filed. Next, will mediation make the redressal process longer? In my opinion, mediation has its own advantage. It is already a proven process before the civil court. It will enable the parties to resolve their dispute at a very nascent stage rather than fighting the complete litigation on merits for years. Where a matter has been referred to mediation, the court should also direct in circumstances where mediation is stretching unnecessarily to complete the pleadings in order to save time. This could be one of the measures taken by the court while directing the parties for mediation to safeguard on the timelines where the mediation has failed between the parties. Otherwise, in my opinion, mediation has been proven as one of the effective mechanism and will prove as an effective mechanism before the commission as well.